Hello again, everybody. It's Chris Clark with discgolf.law. Yesterday, we did a video providing an update on Natalie Ryan's lawsuit against the PDGA and the Disc Golf Pro Tour. This is a follow-up to that video. If you haven't seen it yet, I would urge you to go check that video out and then come back to this one. That way this one will make a lot more sense. As you know from that video, last week, Natalie Ryan's legal counsel filed a motion for a temporary restraining order in federal court in California, asking that the court require the PDGA and the Disc Golf Pro Tour to allow Natalie to compete in the OTB Open this weekend in the FPO division. Natalie's counsel filed this as an ex parte motion, which means that they were asking for a ruling without the involvement or response from the other parties involved. The court denied that part of the request, but did impose an expedited time frame for the parties to respond. The defendants, that is the Disc Golf Pro Tour and the PDGA, were required to have their objections to this temporary restraining order filed in court by noon on Monday. I will note that there is a third defendant in this lawsuit, Thousand Rated Productions. It appears that the parties have, at least for now, taken the position that Thousand Rated Productions is merely a local production company that helps facilitate the tournament and doesn't really have any ability to change the policies of the PDGA or the Disc Golf Pro Tour. So for now, as we talk about the defendants, I'm really just talking about Disc Golf Pro Tour and the PDGA. So as part of this expedited timing that the court imposed, I mentioned to you the defendants were required to have their objections filed by Monday at noon. And then Natalie's counsel was required to file a response by noon yesterday, which was Tuesday. Natalie's counsel did file a response. There's not a whole lot of new information in there. A good amount of what was filed really falls into a couple categories. One was some procedural points that were being made and some questions relative to jurisdiction. To be honest, those points are boring even to me, and I love reading these kinds of documents, so I'm not going to really go into those here. There are 2 points in Natalie's response that I think are worth touching on. The first one is Natalie's counsel made the argument that this temporary restraining order forcing the defendants to allow Natalie to play in the FPO division in the OTB Open is in the public interest. Keep in mind, we're in court in California now. Her attorney cited lots of examples where California law prohibited discrimination against transgender individuals. Part of what he wrote said, "It is the policy of the state of California to avoid discrimination against transgender Americans." The second point that I think was really important and relevant, and I'm going to read it directly from the court documents because I think this is a really well-written and well-articulated paragraph. Defendants' arguments seem to rest solely upon their claim that their policy is not discriminatory because it somehow creates fairness in competition, and its purpose is not to exclude, but to protect. However, there is no such doctrine in California law. The facts here are clear. Plaintiff is a woman in the eyes of the state of California. As a woman, she would be eligible to compete in the FPO division at the OTB Open if she were not also transgender. Thus, the only basis for her exclusion is her status as a transgender woman. This is the very definition of discrimination. Now, whether you agree with the policy or not, I think that is a pretty persuasively written paragraph. If the court buys into that argument that I just articulated in that one paragraph that was written by Natalie's lawyer, I think Natalie has a chance of succeeding on this temporary restraining order motion that would allow her to play in the OTB Open in the FPO division. There is a hearing on this matter in just a few hours in federal court in California. I know that there will be many touring FPO players attending the hearing. As soon as we hear something, as soon as we know something from the court, we'll be back on here to let you know. Thanks a lot for watching.